On this episode of Law Weekly, we bring you some of the highlights from the Southeast Policy Summit on Criminal Justice Reforms organized by the Southeast Body of Attorneys General under the chairmanship of the Attorney General of Ebonyi State, Dr. Ben Odo. We also speak to the Attorney General of the state on some of the recommendations from that summit. In Osun State, judiciary workers have vowed to continue their indefinite strike even as the NJC declines Governor Adeleke's request to replace the state's chief judge with the next most senior judge. Thus our recap of the top trending legal stories in the news. Hello and welcome to the program. I'm Shola Shiele and it's good to be back on your screens after taking a month-long vacation. Now we kick off today's show from the Southeast, specifically from the state dubbed the Salt of the Nation. And I'm talking about Ebonyi State, which is doing amazing work with reforming its justice system. I'll tell you a bit more about that in my conversation with the Attorney General of the state, Dr. Ben Odo. But let's begin with the Southeast Special Policy Summit on Criminal Justice Reforms and presentation of Model State Correctional Service Law, which held in the state recently.
An initiative of the body of Southeast Attorneys General, the 5-day event which held in the Ebonyi State capital, Abakaliki, attracted government officials, attorneys general, judges, magistrates, lawyers, heads and top management officers of criminal justice institutions and agencies, members of the armed forces, law enforcement, security agencies, and many others. They are all here to brainstorm on simple, practical, and cost-effective mechanisms for crime management, caseload reductions, and the decongestion of the correctional centers, as well as the need to enhance access to justice through alternative dispute resolution (ADR), plea bargaining, and restorative justice in civil and criminal justice reforms. The host, the chairman body of Southeast Attorneys General and Honorable Attorney General of Ebonyi State, set the tone for the opening ceremony of the summit by identifying that one of the major challenges to economic development and democratic stability in the Southeast is the deteriorating state of the criminal justice system, which has led to a high state of insecurity and poor investor confidence.
Go to Enugu, go to Abia, go to Igbo, go to Anambra, you don't move on Mondays because of the fear of your own government. And the question is, what should we do to cure the evidence? That is the reason why we are here to answer that call. When we need to work on our criminal justice system to have a paradigm shift from the retributive justice system that we have to the restorative justice system that we ought to have. The body of the Southeast State Attorneys General decided that we'll come together to answer this question. Because all of us that are here are the critical major stakeholders of the criminal justice system of the Southeast. We want a system where the government is spending so much money in putting children in a warehouse called correctional center. We want a system where it will be changed from putting them into this center, spending so much money putting them there, to spending the money, so much money in giving them a very safety, headway, moral life to live.
The special guest of honor, the Attorney General of the Federation and Minister of Justice, Senior Advocate of Nigeria, Lateef Fagbemi, told the gathering that the federal government is highly committed to transcending the status quo and crafting a criminal justice system that not only meets the needs of the present, but also sets the foundation for a more secure and prosperous future for the country. He encouraged the chief law officers of the Southeast states and all relevant stakeholders to pursue the enactment of uniform civil and criminal procedure rules for proceedings before all the superior courts of record and to borrow from global best trends in criminal justice administration.
In our pursuit of revitalizing the criminal justice system in Nigeria in general and Southeast in particular, it is incumbent upon us all to cast our gaze beyond national borders and draw inspiration from successful global models. Countries such as Norway and Netherlands have become trailblazers, demonstrating innovative and effective approaches that redefine the landscapes of criminal justice administration. Norway and Netherlands, for example, stand as exemplary model in the realm of criminal justice administration. One will draw inspiration from global models that have successfully shaped criminal justice administration. This government is ready to work with you, and together we shall confront challenges inherent in integrating these innovative approaches into the Nigerian concept. You will agree with me that the judiciary, which is a critical and fundamental component of the criminal justice system, can't be left out of these conversations or engagement. I will therefore challenge my colleagues, distinguished attorneys general, to support the full implementation of the independence and prudential autonomy for the judiciary across our states, as provided for under the Constitution, as a mark of our true and holistic commitment to ideals of democracy, good governance, and rule of law.
The host governor, Right Honorable Francis Nwifuru, who declared the summit open, noted that it provides an opportunity for all stakeholders to acquire knowledge. He also assured participants that the outcome and recommendations from the summit will be an investment in public security, peace and development, all of which reinforces the pillars of the rule of law and sound democratic culture.
The design of any country's criminal justice system is a reflection of its social and cultural orientation. Since criminal justice is an instrument of social control, which must be hinged on the cultural menu wherein it operates. For the criminal justice of any state to be effective, such a state is required to create its own institution of social control and a proper sequence in the process of administration of criminal justice, which reflects in popular societal norms and values, since law is an instrument of social engineering. Continuous change in the social interactions and civilizations demand a progressive review of sequence of events in criminal justice system in Nigeria. The summit is a unique one, opportunity to all key stakeholders in criminal justice delivery to acquire sound professional knowledge and skill about these concepts that are globally recognized as viable alternative to retributive criminal justice system we are practicing today in Nigeria.
The Executive Director of Prisoners Rehabilitation and Welfare and Action Power, Dr. Ojo Agamo, whose organization is a partner in this summit, spoke to the gathering about the Model State Correctional Service Law.
Model State Correctional Service starts by stating what the objectives are, the principles, the guiding principles concerning this particular law. And it is important that we stress this so that we can actually have the way of making certain connections.
The summit also took goodwill messages from other partners before breaking into a smaller group for the technical sessions, which examined issues of fast trials, case filtering in criminal justice reforms, ADR for crimes, restorative justice, and much more.
Welcome back. I sat down with the host of the Southeast Policy Summit on Criminal Justice Reforms, Dr. Ben Odo, for a short conversation on some of the key takeaways from the summit.
The major takeaway from this summit is stakeholders themselves made a projection and comprehensive proposal to the stakeholders on ways of reforming the justice system in the Southeast. And my major takeaway from this is that the proposals we gave them, they unanimously on their own had to select the one that will be suitable to the Southeast region and the one that will be amenable within our environment. For example, we gave proposal of one, either having the concept of case filtering into our criminal justice system or prohibition of lay prosecutors. And they unanimously agree that there is no need for case filtering, that they would prefer to that lay prosecutors be prohibited in our prosecution of criminal matters in the Southeast states. Anybody who is prosecuting either police, NDLA, DSS, civil defense, they are all doing it on behalf of the Attorney General with their fiat. But what they do at the police station is that they have IPOs who are skilled in prosecution, but they are not lawyers. They've not gone to law school, they've not been called to bar. So we agreed in this conference that they should be prohibited from prosecuting our matters because various Ministry of Justice in the Southeast have enough lawyers to do the prosecution. So we do not need policemen. The policemen who can prosecute for us now are policemen that have been called to bar. That's just one of the proposals. Second proposal is that we saw the region saw the Delta State Administration of Criminal Justice Law of 2023 as a comprehensive criminal administration of criminal justice law. It's a unique legal framework for the administration of criminal justice. So the 5 states in the Southeast have agreed to compare notes with Delta State, and if need be, amend our own administration of criminal justice in the 5 states patterned after Delta. Because Delta now, in this summit, have been agreed by the 5 Southeast states to be our model. So as we go home from this summit now, every state is expected to go home to amend the administration of criminal justice. And then our model in the amendment is the Delta. There in Delta, administration of criminal justice law, they have prohibition of lay prosecutors. We have agreed to do so. They also have prohibition of trial within trial. There's a stay of proceeding in criminal matters. We're going to inculcate it in our own.
So that we can fast track
fast track proceeding. They introduce case management conference in their own. So we're going to be introducing case management conference in our administration of criminal justice law, where just like pretrial conference in civil litigation, in criminal litigation, all the parties, the criminal defendant, the victim, the witnesses, they all have meeting before the trial to agree on the way that it will, and if need be, for the judge to give the lifespan of the proceeding, it must be done. Now, Delta also introduced the Administration of Criminal Justice Monitoring Committee. So we're also introducing it into ours, and we have agreed that there will be a committee that will be set up by the 5 states to monitor the implementation of these laws. And another thing is that Delta also gave the chief magistrate of various magisterial districts in Delta State the power every month to go from one police station to check through the register of the arrest registers to see people that have been in police cell for more than 48 hours without being arraigned in court. Now, the magistrate will be empowered to grant them bail at the police cells, at the police station. And if it is a one that can be charged to court, we compel police in his or her presence to charge the matter to court. If it's a one that should be disposed of, will be done. So the powers of the magistrate have been extended from the magisterial district court to the police station. So the magistrate can move from the police station, preside over a matter there, give judgment, discharge and acquit anybody at the police cell. So these are the things, the innovations we saw in Delta. And we said, look, as we go home, we're going to adopt everything to be part of ours in the Southeast states. Then the correctional, you asked. Now we have agreed that Ebonyi and a number out of these 5 states already have a draft bill of the State Correctional Service Law. It's an executive bill, but because of this citizens engagement, we are going to take it from next week to the Chief Executive officer of the state, the governor of the state, for all transmission to the House of Assembly. And then if it is transmitted, it will be passed, the governor will now assent into it. And then, now we already have a farm, and we're taking over that farm. The farm is moribund. It has been a state farm, so we're taking over that farm, converting same to be our prison farm. Once these farms are in place, and people are sentenced to the prison farms, they are given jobs. They earn money while they are there. The money is, an account will be opened for them in a Ebonyi own draft, the draft bill. We made a proposal of the sharing formula of the proceed from the farm at ratio 50, 20, 20, 10. 50 will be saved for the inmates. You've given him a job, when he's out of the place, you need to fall back to something. So you save that 50% of the total money made while in the farm. 20 will be used for his feeding. Government will no longer feed them, so they generate money to feed themselves while in the unit. 20% will go into government IGR. Then 10% will go to the correctional service. So they will not think that, oh, monkey they work, babu they chop. They're making this money and giving it to government and giving it to inmates. What will they benefit?
So it's a win-win for
yeah, so the Nigerian Correctional Service will have their own share. The victim, the accused person will have the criminal defendant will have his own share. Government will also benefit. So it's a win-win situation.
Away from the southeast to the southwest states of Osun, the Judicial Staff Union of Nigeria Osun State Chapter have said that they will continue their 2-week-old strike until all their demands are met.
It's no longer news that the judiciary workers in Osun State are presently in an industrial strike owing to what they describe as unfair treatment by the State Chief Judge, Justice Oyebola Ojo. For some critical actors in the state, it's time to bring an end to the industrial crisis. So it's a day of meetings for the judiciary workers' representatives. First, they meet with the Honorable Speaker of the House at the Osun State House of Assembly complex. Earlier, the House of Assembly had passed a resolution to the state executive demanding for the reinstatement of the judicial workers under suspension and the payment of their salary arrears. The Speaker emphasizes that the House is only performing its constitutional duty by investigating the allegations leveled against the State Chief Judge, Justice Oyebola Ojo.
But when it comes to probe, they are saying it's not our duty to probe. Then they should go and read sections 128 and 129 of the Nigerian Constitution. And the truth is this, let me use this opportunity again to explain to the general public. I, Adewale Bedun, and the 8th Osun State House of Assembly, we are not trying to enchant anyone. But I have this at the back of my mind when I became the Speaker of Osun State, that I will always give it my very best.
The judiciary staff also met with the governor, who was represented by his deputy, Kolawole Adewusi.
I want to assure you, as soon as His Excellency is back, everything will be looked into in total, and you will see the way my Oga is going to attend to them.
When the two meetings are over, the chairman of Jusun in the state appreciates the state government for paying the salary arrears of their suspended colleagues, but insists that the strike continues until all other demands of the union are met.
We are still expecting more to be done as regards all judiciary workers. Among our demands, we have our wardrobe allowances. We have the completion of the regularizations and promotion exercise. All this, we believe, if we show our appreciation for the little that the government has done, there is hope that we will get the rest.
A timely resolution of the crisis and subsequent call-off of the strike by Jusun is imperative to bring back life into the judicial system in Osun State.
Despite the lingering issues between the judicial staff workers, the government and the leadership of the judiciary in Osun State, the NJC has refused to allow Governor Ademola Adeleke to swear in the next most senior judge in an acting capacity in the state. We have that story and more in our recap of the top legal stories in the news.
The National Judicial Council, NJC, has recommended the compulsory retirement of the High Court judge in Osun State, Justice Oyejide Falola, as it sets up panels to investigate 51 petitions against others over various acts of misconduct in the discharge of their judicial duties. The Osun High Court judge was recommended to Governor Ademola Adeleke for compulsory retirement for granting fraudulent orders against the provisions of the law. At its 104th meeting held in Abuja, led by the Chief Justice of Nigeria, Justice Olukayode Aruola, the council invoked its constitutional powers and placed the judge on indefinite suspension from duties, pending the time Governor Adeleke will give effect to its recommendation. The council, however, declined the request of Governor Adeleke for permission to swear in the next most senior judge in the state in acting capacity, following allegations leveled against the Chief Judge, Osun State, Justice Adepele Ojo, and the resolution of the State House of Assembly to suspend him. The council affirmed that Justice Ojo is still the recognized Chief Judge of Osun State and will not work on the resolution of the State House of Assembly, as it is the only body constitutionally empowered to investigate the judicial officers and recommend same for any action to the governor. The NJC also recommended the appointment of 11 justices to the Supreme Court. The recommended candidates will be sworn in after the approval of their recommendations by President Bola Ahmed Tinubu and the subsequent confirmation of their appointment by the Senate. Staying in Abuja, a 5-man panel of the Supreme Court led by Justice Inyang Okoro has dismissed an application that sought to remove Governor Hope Uzodinma from office on the grounds that he was not validly nominated by the All Progressives Congress to contest the election that led to his first tenure in 2019. The application further sought to invalidate the years that Governor Uzodinma spent in office as the governor of Imo State. The Apex Court, however, held that it had no jurisdiction to entertain the application, which it described as frivolous and highly vexatious. The court subsequently awarded a personal cost of 40 million naira against the counsel to Mr. Hedioha, Professor Mike Ozakeme. At the Federal High Court, Abuja, Justice Inyang Eko has ordered the Kogi State Governor Yahaya Bello to pay the sum of 500 million naira to the governorship candidate of the Social Democratic Party, Murtala Ajaka, for violating his fundamental rights. Justice Eko also ordered Governor Bello to publicly apologize to Mr. Ajaka for the gross and unwarranted violation of his rights. The judge further made an order of injunction restraining the security agencies from arresting, abducting, detaining, or further harassing the life and properties of Mr. Ajaka. In a similar manner, a 3-member panel of the Economic Community of West African States Court of Justice has ordered the government of the Republic of Benin to pay Mr. Sunday Adeyemo, popularly called Igboho, the sum of 20 million CFA for his unlawful detention. The court ordered that the money should be paid within 3 months. Mr. Adeyemo was arrested alongside his wife in Cotonou and detained at the request of the Nigerian government. On February the 10th, he filed an application before the court challenging his arrest and detention in the French-speaking country. The ECOWAS court also directed the country to comply with this order and revert to the court with evidence of payment. And we round up with the report that the Lagos High Court sitting in Ikeja has sentenced Wahab Hamid, a ward leader of the All Progressives Congress APC in the Surulere local government area of the state, to a 1-year jail term, or in the alternative, a fine of 1 million naira. Justice Ismail Hijelu sentenced the defendant after convicting him on a 2-count charge of conspiracy and bribery. The EFCC prosecutor Samuel Daji told the court that on February 25, 2023, the defendant conspired with one Segun Ejitola, who is still at large, to corruptly bribe voters during the 2023 presidential and National Assembly elections. The offense was committed at Unit 28, Baja Girls Junior High School in Surulere. The defendant pleaded guilty, and the court subsequently convicted him and sentenced him to a term of imprisonment for 1 year or an option of 500,000 for each of the 2 counts against him. Justice Ijelu also ordered the forfeiture of the proceeds of the crime to the federal government, while ordering the convict to give an undertaking to the EFCC in writing to always be of good behavior and to never indulge in crime again.
And this is where we adjourn proceedings for today. Do remember to check out the Channels TV website for a replay of this episode of the program, as well as past episodes. Please also send in any feedback via our social media handles. I'm Shola Shoele. Thank you for watching, and see you next week.